Hi, this is Mark Katzenbuehler. Thanks to everyone. That was a really interesting group of talks. I have a couple questions, but I guess I'll just start with the first one for Sally. I was wondering if you could talk a little bit more about, you talked both about social science that already existed that was informative to the questions that were germane to the case, but also this kind of bidirectional interaction where some of the conversations that you had with Susan ended up, it sounds like, generating some additional studies that she went back to do into the lab that were informative to the case law and the litigation. And that often doesn't happen in academia, where we're not always asking the sort of policy relevant questions. And so I'm curious, it seems that often happens in these sort of one-offs, that it just happened to be that she was working on a case with you and that sort of generated it. But it occurs to me that if there were sort of fora or situations where that could happen in a larger way, that social science data might be more helpful or generative than it currently is. And so I'm wondering if you have any thoughts or ideas about that in terms of how to create more situations where that, or more opportunities for that to occur than it does currently, where it really just seems to be, one lawyer working with one social scientist on an amicus brief or on a court case.
Well, I think that we can find analogs in the ways that interest group organizations work. We can borrow from them, even though the National Academy of Sciences is an interest group of that sort. But having roundtables or working groups that come together, I'm hearing Craig's the work that Craig has gone over. I could easily imagine bringing together lawyers who have an expertise and have been working on these cases, often to the point of utter frustration, identifying issues of great importance and kicking them around, and getting together with social psychologists. And I can imagine lots of different ways of doing that. You don't have to put you in the same room. But I have no question that both sides of the equation, but the policy side, three sides, I guess I can imagine, litigation side, the policy side, and the science side could all very much benefit from interventions like that. And particularly in the area where we're working on dignitary harm issues that are very hard for the public to understand, and sort of discrimination or, despised minorities or excluded minorities is are particular areas in which doing this work, I think, could really improve everybody's work in every direction.
Craig, I had a question for you. I guess listening to Sally's talk, and sort of the different areas that she outlined that had been really helpful in the discrimination and sexual harassment field, I'm wondering if some of the cases you've worked on, you've wished you had access to particular social science data related to bullying, and if so, what that is. Because on the one hand, I was thinking as you were talking that it seems like you've really been able to make the harm argument maybe without drawing as much on the literature, but that one of the real stumbling blocks or hurdles for you really is more on the school side in terms of really documenting that, this idea of reckless indifference. And there I'm not as sure about how the social science data could be helpful, although maybe I'm just not thinking about it. So I'm just wondering if you could sort of comment on the use of social science data within the bullying context.
Sure, and yeah, thanks for the question, and I did appreciate Sally's talk, and we talked a little bit offline as well. I would love to have that information in front of a judge. I would have loved to have had it on case intake. One of the first points that she made was knowing what to look for, and to know that this fact may not be an obvious fact, but could be a compelling one to a fact finder or a decision maker. Lots of times, because of the way the federal rules of civil procedure are written, we get our complaint drafted, we get our discovery started, and then we start thinking about our expert. But if you take Sally's idea of having this expert to develop elements of proof, to develop what the landscape of facts would look like, and then to go, digging through the case file to find if those facts do exist, that would be very helpful, especially as these aren't mass cases. This isn't, the type of litigation where we have hundreds of cases. We get these cases, generally they're flowing, but they're not flowing heavy, and so we haven't created a critical mass, at least not down here in Georgia or in the 11th Circuit, of fact patterns to look through, to see, oh, well, that happened in our case too. And so to have a scientist or social scientist say, the impact of this is consistent across lines, it's the science that this is what happens when you have this phenomena, I think that would be helpful to start. And then, obviously, to have somebody besides the family, to have somebody with those credentials giving some compelling context to the incident. So the incident is egregious. The incident, just like Judge Murphy would tell you, the incident is awful. The child kills himself because he's been harassed for years. But that still isn't going to win the day for you. But if we had that context to change that decision-maker's landscape, to give him more as to how this happens, the fact that it happens in a particular way, and there is responsibility on a high level for that, I think it would be effective. We haven't had an opportunity to do it yet, but as these cases move forward and we get more of them, if we don't see changes in the law, I think that will be the next step.
Fred? Hi, this is Fred Rivara. Is there anybody writing any sort of model state laws that states should be following and adopting regarding bullying?
I think that's yours, Craig, if anybody's.
Sarah, do you want to weigh in on what?
Let me answer it by saying when I started looking into it, it said that Georgia was the first state to pass anti-bullying legislation. Having been down here since '98, I'm from Florida, but practice in Georgia. I know that the states have them now. I think they all are consistent with what I'm seeing. At least I hear lawyers across the country saying that. One of the things that they have yet to do is to dive into empowering the victim, to give the victim rights and decision-making power. It's just the most obvious thing that a bullier who's removed from school is coming back to school eventually. And even though families scream about this reality that, unfortunately June is only 2 months away from August, that schools simply do not allow victims to move schools because they are a victim as a matter of policy. That to me is just, it's inexcusable, and we just simply cannot get over this hurdle. So that would be, kind of heading off in a different direction. But Georgia's the first, and it's still on the books. It has not been updated or amended or improved, and we still get these, really, really difficult situations without the legislature taking any action.
There's some documentation on the U.S. Department of Ed. Deb Timken was really involved in some of that, weren't you? Like you reviewed all the different state policies and then pulled out some themes and made some recommendations. So there has been some review. I don't know the extent to which that's been updated since you transitioned.
Thanks, Deb. I know that you've been integral in this work for a long time. So in 2011, as Catherine and Deb were saying, Ed published an analysis of bullying laws and policies and their implementation. And they also highlighted 11 components that they felt kind of made a good model policy. And so you can find that information on stopbullying.gov in the laws and policy section. And to my knowledge, it has not been updated since 2011. But the laws and policies section for each state is updated yearly.
Is there any evidence that good laws result in less bullying?
This is Beth Edgerton. I can respond to that out of Iowa. Corey Picasa and her group have actually looked at that and taken the template that the Department of Ed has put forward of the domains, looked at states that collect the Youth Risk Behavioral Survey, and have been able to link associations around that. So if a certain element is implemented, what impact does that have? And so I think that's going to be published in Pediatrics, either it has or coming soon. So there is data that's looked at it at the state level.
I think the question is the implementation of those laws, though. That's really, at least anecdotally, we've been doing research in Maryland about the implementation of their law, and part of it is that they provide an opportunity for kids to report bullying and parents and families, but like 2/3 of our teachers have never even been trained on the model, so it's really hard to implement a policy you've never been trained on. And we ask kids if they're aware of it, so we have kind of a surveillance system in place in the state to be able to look at this. So there's my experience, at least in Maryland, has been pretty low implementation of these policies and great variation in implementation quality across school systems. Some systems really embrace them and do a great job with them and end up having a lot of files on kids, and then some systems don't implement, and then they end up looking like they don't have any bullying. So there's great variability in terms of implementation and the extent to which they get fully embraced by both the states and the school systems. So.
Craig, I wanted to follow up on a point. Given the relatively small number of cases and the inevitability that you have to think about it in part as addressing the needs of the particular individual and also in part as impact litigation, on the latter point, what would you want to see come out of the litigation and feed back into potential legislation?
That's a good question. Just like I had mentioned, I would like to see more empowerment of the victim, giving them some opportunity to be involved in decision-making in their future. I think that's a piece that's still missing. If we have, in Georgia, limited implementation of positive behavior intervention supports, PBIS, and school culture type of programming, that I think is a statewide, responsibility. It is the science now for improving, across the board behavior management in schools. But I think it has a particularly impactful place in this issue of student-on-student harassment. If you improve school culture through the use of positive behavior intervention supports or PBIS, you're going to address the way students are managing each other or interacting with each other, and I think that's something that's not beyond the pale. The state, if you were litigating this as a state issue, I think that would be the second thing I'd like to see. And then the third thing I'd like to see is, addressing what happens next. I think we have a reactive policy that stops with the discipline, but doesn't go further on either side, for the victim or for the bullier. And so you're left with the same situation in August that you had in June when the third act of bullying occurred. At least that's how it is here in Georgia. But no responsibility on part of the school or the state to plan for that. And then we're shocked when it happens again. And so we don't have a what happens next piece of our policy. And I think our state should be responsible for that.
Did you have a question?
No, okay.
Then can I shift gears and ask a slightly different question? Oh, sorry.
Well, I was actually going to follow up on Catherine's comment about implementation back to the state laws. A lot of the work that Child Trends has been doing here in the District of Columbia has been working with them to implement the Youth Bullying Prevention Act of 2012 that they passed. And one of the first things we did was actually look to see if the schools adopted the policy that they were required to adopt even a year after when they were supposed to. And on initial submission, less than 30% had the law or had the policy as compliant with the law. Once we worked with them to actually tell them what they needed to have in their policy, we got that number up to about 75% at this point. But it took that intensive technical assistance to work with those schools for them to understand what those laws were actually requiring of them to put in their policies.
So can I get in one more
Yeah,
question?
I have one question from the webcast. It's this question is from Lynn Mock. It says, can neuroscience imaging be used in legal cases to show changes in the brain or comparisons in the brain regarding the impact of bullying on the target? Or can neuroscience be used in any way to provide compelling evidence in legal cases?
The question, I think, the answer to that question, I think, would depend on meeting the Daubert standard for expert testimony and foundational for getting the neuroscience imaging admitted in court. Do you agree, Craig?
To the extent you're in federal court, yes. We have some of this in administrative hearings without having to, manage a Daubert issue just simply because of the nature of the forum. I have not seen it as impactful as I thought it would have been. The science there really, when I was talking to the doctor, I was truly impressed by what he was finding and the opinions he was rendering based on that science. But this could be a regional thing where we're just simply not there yet. But I think that, yes, you could use neuroscience imaging. You could, and if you did, make your showing in federal court that it was the science and your opinions were valid opinions to be given, then I think you could use it. How impactful it would be is a question, I think, that remains.
So I wanted to ask a question that relates to some states' recent legislation and that it really potentially expands school authority beyond school grounds, particularly in the context of cyberbullying. And I'm wondering if you could maybe Craig and Sally primarily comment on that. And I'm thinking about it from two perspectives. One is, does it change school responsibility from a deliberate indifference standpoint? And then two, should we be concerned for the accused or potential accused about privacy concerns and sort of boundaries that perhaps should be in place for schools?
Craig?
Thoughts on that sort of that?
Hold on, let me get my ACLU card and put it right up here in the front so you guys can see it when I talk about your First Amendment rights. So I think you're right. There's going to be some First Amendment concerns that we're going to have, and as somebody that represents students on all these educational civil rights issues, I am concerned about that. That's going to have to be weighed against the interest that a school has in trying to protect that issue. For me, really, I have not had cases of cyberbullying where I've gotten into the First Amendment response because I would be trying to help out the victim, and the way it would play out just logistically is that the family of the perpetrator would say, well, you can't come into my Facebook account or you can't come into my AOL or whatever it is because I have privacy rights. And that's going to be something that I think schools are going to have a very difficult time managing. I do know that there is some litigation out there about your First Amendment rights when you are engaging in what is ultimately school activity because of the nature of the participants and the forum. So the school is opening up a Facebook page for Grady High School here in Atlanta. And if there are participants on Grady High School's Facebook page that are bullying, I think then Grady High School has responsibility. When it is independent of that, then I think we're going into a grayer area. Now, with respect to their reckless indifference standard, what I think that they're going to have is not less but more responsibility. I think they're going to have to spread their net even further than they believe they had to in the past. It's a very legitimate defense, and it's one I've heard over and over, that simply wasn't on school grounds. That wasn't within the jurisdiction of school discipline, and so there is nothing that the school will do for you. Call Atlanta Police Department. But now, people are bringing their mobile phones onto campus, and then they just simply walk across the street. I think that if they are students engaging in student behavior through possibly, authorized or sanctioned school outlets, then I think the school's going to have to reach further in, and I don't know that they'll be able to shield themselves from liability as easily elsewhere. Here, it's still going to be a very difficult road. But it's a fascinating issue for sure.
So, this being America, how come the schools aren't worried about financial liability for the bullying that goes on? It seems like lawsuits and the chances of losing millions of dollars in a lawsuit would motivate school districts to do something about it. Are you guys not aggressive enough in going after the schools, or what's the problem?
Well, we just wish we had better results. I think that the intention is there. It's a good question, and I touched on it a little bit because the discussion is a very complicated one. But ultimately, the agency is shielded by immunities, by official immunities, and then the individuals that work for the agency are also immune from suit unless you can make a showing, especially for money damages. So if we were talking about injunctive relief or declaratory relief or trying to get a policy addressed, we don't have to worry so much about these immunities. But if you're asking about money and holding a school accountable through damage actions, and to do that when you sue a state, you're going to have to make a higher showing and jump through some significant procedural hurdles in order to recover. And that ultimately is what schools know. I think that, media aside, the school's concern more is the administrative burden of dealing with litigation rather than the ultimate fact that they're going to pay out, at least down here in the 11th Circuit, where our qualified immunity and our official immunity cases create a very high threshold. In the 2nd Circuit and the 9th Circuit, I think that you do see these settlements happen more often than they do down here. And to be quite frank, schools know this and litigate to it, meaning that they defend vigorously. They protract litigation because families have limited resource and they have a deeper pocket, and they can really manage their litigation responsibility or burdens that way. It just simply isn't as easy as filing your lawsuit and then collecting your check. It just doesn't happen, at least down here.
I think it's difficult anywhere.
Thank you. You make me feel better.
Thank you.
Can you just introduce yourself?
Karen Fry, University of Washington. So I was thinking about a little bit of information from research on justice theory that might be helpful for you. We know that personal retaliation, revenge, is higher in societies in which access to institutional structures for providing deterrence and providing justice are not accessible. Traditionally, this is because you're perhaps herding goats 300 miles away from any kind of police situation, but it could also be in societies in which they're war-torn anyway. If you don't have access to justice or protection, then the tendency is to increase personal retaliation. Now, I wonder about this. It's an empirical question on school grounds where students feel that they are not protected and they're not given justice. Reactive aggression is a way that people use to get some sense of justice in their lives. So that's an interesting kind of thing. The other thought is that we know when certain groups, because of stigma, are not able to get equal access to justice, then it affects self-identity development. Specifically, you feel that your self-worth is replicated by the potential you have to get justice in society. So two aspects that you might want to think about. they're not going to win you any cases yet, but
But I think it argues for this local level alternative disputes process to be more emphasized, the school mediation. We've had a few programs run. I believe we had one down here in Clayton County, Georgia, where it was started by the juvenile court, but it was implemented on the school grounds, where if you had maybe an assault or a simple battery in school, that there would be a mediation on the school grounds and try to get a resolution there and give the access to justice. I can tell you that I have not seen the bullying policy, anti-bullying policy, and anti-bullying statute shift that way. It seems to be about penalties and policies as opposed to this access to justice, which you're talking about, which I think is really an interesting idea. So hopefully we'll see more of this local, low-level dispute resolution. I think it would be effective.
Are there other questions? Sandra.
I'm Sandra Graham. I'm a member of the panel. So I want to ask both of you a question about, and this may seem not like a naive question from a legal perspective, but the difference between racial discrimination and race-based school bullying. So in developmental social psychology, these are really two separate literatures. There are developmental social psychologists who are studying the experience of racial discrimination based largely on some of the social psychologists who've done this work with adults and some of you whom you've mentioned earlier. So it's a literature on the experiences of being discriminated against in school from peers and teachers, and it's a very distinct, separate literature from peer relations researchers who study bullying in schools, and they may be particularly interested in racial ethnic minorities who are experiencing bullying. And because we know that if you're a numerical minority and you're an ethnic numerical minority, you are more likely to be experiencing bullying. The assumption is that it's race-based. But these two camps don't talk to each other at all. So I guess my question is, are we, and I'm in the camp of a peer relations researcher who studies school bullying with a particular focus on the experiences of ethnic minority kids. So are we, in a sense, not helping the cause, the litigation cause, by not linking ourselves more closely with researchers who are studying racial discrimination? And so I guess my question is, what's the difference from a legal perspective in racial discrimination, where the perpetrators might be your peers, not the adults, and the experiences of race-based bullying in school? Is there any difference between those?
I'm inclined not to think there's a huge difference. I think, but I would say that one of our challenges whenever we're dealing with the group membership target bullying or target harassment, it's interesting because it's the race of the person who's being targeted, but the dynamic is really arising from, and its behavior from, and it's generally the cognition of the person who's doing the harm. And that's one of the real challenges in these cases. And if you look at it from that perspective, I think that, in my experience, we gained a lot by shifting the focus to, and keeping the focus, certainly in the first instance, on the, if you will, perpetrator, whether it's race, whether you call it race-based discrimination, race-based harassment. I won't presume, because I think there's said to be some differences with bullying, but I would think that they're on a continuum and they're very closely related in terms of the behavior. I mean, what motivates somebody to be overtly nasty and abusive, of course, is always the additional question in the harassment, and I suspect bullying. But yes, I think talking more to each other has a lot of upside.
I think we have one last question or comment from
It's a generalized comment, but if there are any other questions, they should be asked first.
So I think we'll hear the last comment then.
Okay, the comment is, it says, for the final wrap-up comments, I'm Rich Seitz, I hope I pronounced that correctly, Ocean County, New Jersey Department of Juvenile Services, 30 years, juvenile detention, shelter, juvenile court programs, teacher, coach, father of 5, grandfather of 12. Last meeting I spoke in the darkness of a DC power outage about the Raiders of the Lost Ark. Last night, a major storm with a power outage across half of New Jersey and trees across roads blocked me from today's meeting. Hearing today's testimony, it appears that there is lots of research and few answers. The complexity of bullying and other issues, such as mental health, has been mentioned. Debate on psychosocial effects all you want, but please read the current research, 30 years worth, on good behavior game and PACS GBG. It obliviates bullying in elementary school, and although that was not its original goal, when one program used for 1 year reduces drug abuse, alcohol abuse, delinquency, conduct disorders, suicidal ideation, suicide, ADHD, etc., it should be obvious to everyone that it is influencing the basic building blocks of our children, whether the prefrontal cortex or heart or soul. To not include implementation of PACS GBG in every...
Kelsey, is there a question there?
It talks about GBG in every, it has one more sentence. In every school, as a first step in combating bullying would be a disservice to your purpose and to the youth you serve. One lawyer's fee would cover the cost and do far more than to protect the district from litigation.
Okay, thank you for the comment. And with that, I think I just want to thank again our 3 speakers for your really informative presentations and answers to the Q&A, and we'll move to our next session. Thank you.
Thank you.